So today we are going to discuss and see how to write answers of Companies Act. So I would prefer, as you already know, always tell you that I would prefer that you guys also keep answering along with, when I'm reading the question, you guys also start telling me or keep telling me what provisions have to be written. Okay? Prashant Infra Height Limited is a public company having 215 members. Out of 215 members, 20 members were employees in the company during the period 1st June to 30th June. They were allotted shares in Prashant Infra Height Limited on 1st April, which was held by them till today. Now the company wants to convert itself into a private. Okay. So basically, it wants to convert into a private company. And when it comes to a private company, what is the maximum number of members? So provision will be obviously we have to write about private company, right? And they have the question is only telling whether they have to reduce the number of members. That is the question only. Whether they have to reduce the number of members. So we have to talk about private company, and more importantly, this provision is based basically on the number of members, right? This provision is basically it is based on the number of members. So that is what we have to write about. So first though, let's figure out the answer and then we'll try writing. Prashant, it is a public company. Employees, there were 20 members were employed from 1st June 21 to 30th June 23. They were allotted shares on 1st April 2017. They were employees from this period to this. But the shares were allotted to them on 1st April, which are held by them till today. That is 31st October 23. One thing to note, the day we are considering, they are not employees. Okay. But ex-employees, if they acquired shares while in employment, we don't count them. So on that basis, they will not be counted. But here, they were employees from this period, but the shares were acquired during this period, so they will be counted or not? Yes. Because the provision says that the shares must be acquired by them while they were employees, correct? So 20 members will be counted. So 215 members. So are they required to reduce the number? Yes. So what will I write here? As per the provisions of the Companies Act 2013 or as per section what 60 sorry 2 clause 68, right? This is the section number. So if you remember the section number as per section, ma'am, am I supposed to write the section number? Let me tell you one thing again for all of you who are confused whether, ma'am, I have to write the section number, whether I have to write what you say, whether I'm supposed to write quote the section number, whether I'm supposed to quote the provisions word to word, whether I have to give reference to case laws. I've already told you that we don't have to do all of these things. So please don't worry yourself on this account. As per the provisions of Companies Act 2013, a private company means a company which has a minimum paid up capital as may be prescribed and by its articles limits the number of members. Now, here, ma'am, should I write all the three provisions of, a private company, all the three provisions of articles? See, if it is a 3 marks, right, don't write. If it is a 4, 5 marks, then do write. So depending on the mark, you have to decide also how much I have to give. But if it is a 3 marks, just write about the number of members, that's it. So the number of members to limits the number of members to 200. Limits the number of members to 200 except in the case of OPC. provided that provided that while calculating the number of members, please ignore my spellings, while calculating the number of members, persons who were in the employment of the company or were formerly in the employment of company. Now, some of you will end it here. No. Ma'am, what is this formally where in the employment of the company? Ma'am, instead of that, can I write ex-employees? Yes, you can totally write ex-employees. It's okay. But if you just write ex-employees, it's wrong because then in that case, this whole answer would only change. So if you don't write the full provision, your answer will only be different. So you just cannot write ex-employees of the company who were formerly in the employment of the company had acquired shares while in such employment. This is the key point. You cannot miss this. Had, this is the technical term. This is the technical, on which basis my answer is coming. So had, there's some problem with the, had acquired shares while in such employment. Please, this is very important. Had acquired shares while in such employment and continue to hold them even after the employment ceases. Right? So please, while in such employment, and this is the most important, okay? Shall be excluded. So this is my provision. Now, second paragraph here has to be a little illustrative. So in the above case, Prashant Infra Height Limited had issued shares to 20 of its employees. They were employees between the period of 1st June to 30th June 2023. They had acquired the shares on 1st April 2017. Since the shares were acquired by them while they were not the employees of the company, for the purpose of membership, they will be counted. Right? So is, what do you say? Prashant Infra Height Limited required to? Yes. Therefore, Prashant Infra Height Limited is, please don't write these short forms in the exam, is required to reduce its number if it wants to convert to a private company. I hope it's clear to all of you. I hope it's clear to everyone. Yes? So, can we move forward to the next question? When it comes to when it comes to Companies Act, no, Companies Act, there are technical terms. So you cannot miss out those technical terms. You have to be very careful while you're writing the answer. So you have to be very, very careful when you're writing the answer in Companies Act, especially in types of companies. Kamal, a chartered, okay. So there was a lot of, dilemma about this question. And I had also posted a video for the answer for this question. And I hope you have tried to figure out, when I had asked you that question, I also tried to figure out the answer. And you've checked the answer also, right? Kamal, a CA, started his e-commerce business. Kamal, a CA, Okay, today my laptop has some issues, I guess. Kamal, a CA, started his e-commerce business by incorporating an OPC. On 1st October, he, being a sole member of the OPC, named his brother Sudhakar with his consent as his nominee in the Memorandum of Association of the OPC. Now, Kamal intends to replace Sudhakar and to nominate any one of the following shortlisted friends as a nominee with effect from 1st Jan 24. Now, if you really look at the act, no, residency is not mandatory, but ICI book has a different take on it. As per the ICI book, they have made it residency is mandatory, and their answer is also given as that. So you have to be careful about it. You have to write as per ICI. So, how will I write the answer? Ma'am, you're writing all this, ma'am. I don't remember. I already told you it's absolute okay. You don't remember, simply write as per the provisions of Companies Act 2013. That's it. Right? So, as per the provisions of, as per Section 2, Clause 62, read with Companies and Corporation Rules, only a, okay. See here the question says 2. Please don't write 1, 2. Only a natural person who is an Indian citizen, whether resident or otherwise, and has stayed in India for at least 120 days in the immediately preceding financial year shall be eligible to incorporate OPC or be a nominee of an OPC. So it's very clear. It's and has stayed. So you have to, residency is mandatory. Resident of India means a person who has stayed in India for at least 120 days in the immediately preceding financial year. A member may change his nomination and appoint any other person as his nominee. Second point is not necessary, but because he wanted to change, I've written main. The whole provision is based on point 1. Again, I made a mistake here. So in the above case, he had started an OPC and he had named his brother Sudhakar his nominee. However, he wanted to change his nominee and appoint someone else in place. Therefore, coming to the conclusion, guys, are you able to follow? Now, from effect from 2024, that means 23-24, he wants to appoint for the financial year 23-24. Now see, they have used 1st Jan 24 and you will get confused here. Oh, 1st Jan 24. That means in 23 you have to see the residential status. But no, please understand here, residential status is given what? Immediately preceding financial year. So he is incorporating the OPC in which year? 23-24. So I have to see the financial status in 22-23. I have to see the financial status in 22-23. Robert, an Indian citizen, and shifted his residence to the US on 31st May 22. So I have to see 22-23 ka status and has not returned to India till 1st Jan. That means for the year 23-24, so he was not in India. I don't need that. I need to check 22-23. 22-23 for April he was 30 days, May 31 days, total 61 days. Is it 120 days? No. So can he be appointed as a nominee? Absolutely no. Robert cannot be appointed as a nominee as his total stay in India in the financial year 22-23 is 61 days. 30 days of April and 31 days of May. Right? Second option. Let's go and see second. Dinkar, I hope you are also trying to solve the question and not just sitting there. There's no point. Dinkar, an Indian citizen and non-resident in India, came for employment in India on 1st April 23 and have been continuously staying in India since then. Now, he was a non-resident Indian and he came to India on 1st April 23. That means in 22-23, did he stay in India? No. So can he be appointed as a nominee? Obviously not. So Dinkar is not eligible to be appointed as a nominee as he did not stay in India in the financial year 22-23. Correct? So I hope this is clear to everyone. I hope this is clear to all of you. Yes. So moving on to the next one. ABC Limited, a company, ABC Limited, I would like you guys to please answer along with me. A company, ABC Limited, had a paid up capital of 1 lakh. In June, ABC issued additional 10,000. We have done these questions in the class, I know, because they were very tricky. I've already discussed these questions. He had issued additional 10,000 equity shares of rupees 10 each, which was fully subscribed. Out of 10,000 shares, 5,000 of these shares were issued to XYZ Private Limited. Okay. So total ABC ka, okay, total ABC ka, how, today my laptop has an issue. Total ABC ka shares is how much? 20,000. Out of this, 5,000 of the shares were issued to XYZ. Private Limited. XYZ is a holding of PQR. It is the holding of PQR by having a control over the composition of the board of directors. Now, PQR Limited claims the status of being a subsidiary of ABC as being a subsidiary of its subsidiary XYZ. That means first, they are saying ABC is the holding of XYZ. That is, they are saying XYZ is the subsidiary of ABC. It's not possible only because ABC is not holding shares in XYZ. XYZ was holding shares. So even if there was a relation, it wouldn't be ABC is the subsidiary. Rather, it wouldn't be XYZ is the subsidiary. Rather, it would be ABC is the subsidiary. Correct? But anyway, to become a subsidiary, you need to hold more than half. Whereas here, the holding is only 25%. So is the claim of PQR Limited correct? No. No. Why? Because XYZ is not the subsidiary of ABC. State the relation, if any, between ABC and XYZ. So here, first of all, I have to write about what? This is very important. When you are trying to figure out a question, the first thing that I really need to do is I need to figure out the provisions. So here, one provision I've understood, I have to write about holding and subsidiary. State the relation, if any, between ABC and XY. Is there any relation between ABC and XYZ? Yes. Because XYZ is holding 25% shares of ABC, ABC is the associate. So that means, can I say I have to write about associate? Correct? It's a 7 marks question. So you have to be quite elaborate about with your answer. Correct, correct, Harsha. Why don't you guys also write the answer along with me? It will be good actually. As per section 2 clause 46, actually this issue happens. I'll tell you why it happens, because I'm streaming from this laptop only. So because I'm using the same laptop for writing and I'm streaming from the same laptop, that is why this issue happens. So please bear up with that. A company is said to be the holding of one or more other companies if such one or more other companies are its subsidiary. As per section 2 clause 87, a company is said to be the subsidiary of another if the holding first controls the composition of board of directors or exercises or controls. If you don't remember this, holds you can write, but more than one half of the total voting power is the key word here. You cannot miss it. The more than one half of the total voting power, either on its own or together with one or more of its subsidiaries, provided that it should not go beyond the layers specified. Further, under section 2 clause 6, a company is said to be the associate of another if such other has a. Why is it important to identify the provisions here? Two reasons. First, you don't miss out any provision. Second, you know in which sequence you have to write the provision. You will start with associate, or you will start with holding, in between write associate then subsidiary. No. There is a sequence. The answer should be smooth flowing. If you mix and match and write, in between some provision, then in between something else, the answer looks very dirty then. It's not very clean. The presentation is not good. So if you already have your answer, this is what I'm supposed to write. What happens is, there you have a clarity. You know what you're supposed to write. You will follow a sequence. The answer looks good then. So further, if such other has a significant influence over it, not being a subsidiary and includes a joint venture. So you cannot miss the word total paid up, total voting power, significant influence. These are the key words. If your answer does not have them, it's problem. More than half, you cannot miss that. The term significant influence means control of at least 20% of the total voting power or business decisions. Correct? So let's look into the conclusion now. So now PQR claims the status of being a subsidiary of ABC as being a subsidiary. Therefore, the claim of PQR is not valid as XYZ is not a subsidiary of ABC. Since XYZ holds 25% of the voting power of ABC, it has a significant influence over ABC. Therefore, ABC Limited, please don't write only ABC, is an associate of XYZ. I think ABC Private Limited it is. No, it's limited only. Of XYZ, is it private limited? Ah, of XYZ Private Limited. I hope it's clear to all of you. Yes? Moving on to the next one. So, excuse me. Excuse me. If you will see, writing answers in Companies Act is taking more time than we had written in partnership. In partnership, so in 1 hour, in half an hour, 4 answers were also done. But we have just completed only 3 answers. So it takes a little longer. You have to be a little careful about the words also. So now, the next question. It seems the Josh of the students has already gone down, huh? The first 2 sessions of writing, people were like, okay, we have to attend. Today, the Josh is only not there. Or maybe it is the New Year's fever. Or maybe they are celebrating someone else's CA final result, waiting for it, huh? Waiting for the results. The state government of X, a state in the country, is holding 48 lakh shares of Y Limited. So Y Limited is a company and the state government is holding how much shares? 48 lakh. What is the total shares of this company? 95 lakh. Government is holding 48 lakh. For a government company, minimum holding is how much? 51%. Correct or not? 95 lakh ka 51% would be how much? Tell me guys. How much would it be? 51% of 95 lakhs. Can you tell me? 50% would be 50% would be 47.5 lakh, right? 47.5 lakh is 50. What is 51%? Come on, calculate and tell me quickly. 48.45 lakh, right? Holding only 48 lakhs. So can we call it as a government company? No. Y Limited directly holds. Now Y Limited holds 2,50,600 shares of Z Private Limited. Thank you. Of Z Private Limited, which is having a share capital of 5 crores in the form of 5 lakh shares. So what is the total share of Z Private Limited? 5 lakh, of which 2,50,600 is held. That means, can we say Y Limited is the holding of Z Private Limited? Yes. Z Private Limited claimed the status of a subsidiary company of Y Limited as well as a government company. Advice. So here I have to write about two provisions. First, I have to write about government company. Second, I have to write out what? Subsidiary company. Correct? These are the two provisions that I have to write here. Am I right, or did I miss out anything? Yes? Okay. So, as per, I don't know why I am always forgetting writing. As per section 2, clause 45, please, if you don't remember, you will simply write. I repeat again, you will simply write as per the provisions of, correct? Section 2, clause 45 of the Companies Act 2013. A government company means a company in which at least 51, please, holding subsidiary is more than 50. Here it is 51. Holding subsidiary is total voting power. Here it is what? Paid up share capital. 51% of the paid up share capital, you cannot write PUC, please, is held by the central government or by one or more state government or partly by central government and partly by state government. I'm telling you, trying to finish off the paper in time, you will literally have, like, your hand is, remember, my hand is breaking. Your hand will break. I'm telling you, not joking. If you don't practice writing, literally after writing one answer, 3 pages, your hand will be like broken. Broken, I'm telling you. So please practice writing. And includes a subsidiary of a government company. As per section 2, clause 87, a company is said to be subsidiary of another if the holding, now please understand, I'm not writing the whole thing again because what we have written here, the same thing we need to write here, right? The same thing we need to write here. So please refer previous answer, right? So what is the conclusion here? whether Z Private Limited is a subsidiary company of Y Limited as well as a government company. Okay, so therefore, Z Private Limited is a subsidiary of Y Limited, as Y Limited holds more than half of the total voting power. Okay, just a second, guys. Just a second. Everything fell down literally. Since the holding of government in Y Limited is less than 51% of the paid up capital, Y Limited is not a government company. As Y Limited is not a government company, even Z Private Limited, which is a subsidiary of Y Limited, is also not a government company. Try to be a little, explanatory in your, what do you say, conclusion. Don't have to be too much of explanatory, but yes, a little bit of explanation. Okay. It's been a long time that ICI has not asked us any question from Section 8 company. So I just chose this one Section 8 company also to discuss. A, B, and C have decided to set up a new club with the name of ABC Club, having objects to promote welfare of Christian society. They plan to do charitable work or social activity for promoting the art of the week. The company obtained the status of Section 8 company and started operating from 1st April 2017 onwards. However, on 30th September 2019, it was observed that ABC Club was violating the object of its objective clause, due to which it was granted the status of Section 8 company under the Companies Act. It was what? Violating the object, that is, breaches the object. And what happens if the company breaches the object? License will be revoked, right? So, as per Section 8 of the Companies Act 2013, if a Section 8 company breaches its objects. Okay, discuss what powers can be exercised by the central government. Sorry, I forgot to read the whole question. Got so excited about the answer. Breaches its objects, the central government may revoke the license. On such revocation, first point, the central government may order the company to convert into a private or public company. On such conversion, the company must add the words limited or private limited after its name. The company must also inform the registrar. Right? Second, excuse me, the central government may, in public interest, order the company to amalgamate with another Section 8 company with similar objects. The central government may, in public interest, order for the winding up of the company. On such order, the company shall be wound up. Any surplus on winding up shall be transferred to another Section 8 company or to the Insolvency and Bankruptcy Fund under the Insolvency and Bankruptcy Code. You need to write full forms, please. Such order shall be passed in public interest. However, before passing any order, the company shall be given an opportunity of being heard. Correct? So this is the provision. Therefore, the central government can pass any of the above mentioned orders. Right? So the next one, XYZ Limited was incorporated to hold the patent for a new product. The company is expecting to start its commercial production within next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of 1 crore. Do you think it's a... So, referring to the provisions whether the company can go for acquiring the status, it has purchased plant and machinery. Do you think it's a significant accounting transaction or not a significant? It is a significant accounting transaction. But ma'am, a company can be formed to hold any assets and it can be declared as a dormant company. I agree. But see what is given here. The purpose of the company was to hold a patent. They have acquired plant and machinery after the incorporation. This is a significant accounting transaction. So can they acquire the status of a dormant company? Obviously, no. So section 455 talks about a dormant company. As per the provisions of Companies Act 2013, a dormant company is formed for a future project or to hold any assets including intellectual okay, including intellectual property rights and does not have any significant accounting transactions, right? Now, significant accounting transaction means any transaction other than first payment of fees to the registrar, second payment to fulfill the requirements of this act or any other act, allotment of shares to fulfill the requirement of the act, and fourth, any expense for maintenance of office and records. So if I see here, purchase of plant and machinery does not fall under any of the four heads. So it is a significant accounting transaction. Therefore, what is the name of the company? XYZ Limited cannot acquire the status of a क्या dormant company as purchase of plant and machinery is a significant accounting transaction. Clear? Moving on to the last one. JV Limited borrowed a secured loan of 5 crore from Star Bank Limited to meet its working capital requirement. However, the borrowing power under its MOA were restricted to one. Okay. So I am allowed to what? Take a loan of 1 crore, but 4 crore was not allowed. So 4 crores was ultra wires. The bank released the loan in 2 installments. On the due date for repayment, the company refused to accept the liability on the ground that the borrowing was ultra wires. The company's books of accounts show that the company has utilized the loan amount of 3 crores for repayment of its lawful debts. The utilization of the remaining 2 crores cannot be traced. Referring, examine the validity of the company denying the repayment of the loan and explain the remedy, if any, available to the bank for the recovery of the loan. Okay. So here we have to write about ultra wires. If you want, you can make a note of constructive notice also, and also how much can be recovered, right? So basically the concept is about what? Ultra wires. As per the provisions of Companies Act 2013, any contract which is outside the scope of powers of the company is ultra wires. Any contract which is ultra wires is void ab initio. A memorandum, when filed, becomes a public document and it is deemed that every person dealing with the company has knowledge about it. This is doctrine of constructive notice. So, if the company takes any loan which is ultra wires, the company can deny payment and the third party cannot recover it. Further, if an ultra wires loan is used to repay any lawful debt, right? If the ultra wires loan is used to repay any lawful debt, then for the lawful debts, the lender steps into the shoes of the creditor and can recover it from the company. So here 1 crore is anyway payable because that is intra wires. Out of the 4 crores, 3 crores is payable because it is traceable to a lawful debt. Therefore, company is liable to repay rupees 4 crore. Rupees 1 crore which is intra wires has to be paid. Out of the 4 crores, 3 crores is traceable to a lawful debt and hence payable. I hope this is clear to everyone. With this, we are done with the questions for today. I hope this session has helped you. I hope you're writing answers. And I hope to see you all again very soon in the next session. If you want me to conduct next session, please let me know in the chat box below. Okay, Prats, just a second. Whoever has asked me this question, Prats, yes, you are correct. The definition says it is formed to hold assets. But here, was the purpose of the company, the reason the company was formed, was it to hold this plant and machinery or was it to hold the patent? It was to hold the patent. In fact, after incorporation, they acquired this plant and machinery. So the purpose of incorporating the company was not this plant and machinery. Prats, I repeat again. Thank you, Jaya. Thank you. I just hope that, yes, it relates to Harsha, it relates to, what do you say? It relates to ultra wires. Prats, did you understand? Please tell me, huh? So basically, see, they are saying what is the motive of the company? The motive should be to hold plant and machinery. Here, the motive was to hold this patent and they will start future production. After incorporation, they decided to acquire the plant. The motive was plant and machinery or the motive was patent? Prats, I repeated it again, please. Okay. We will do that. We'll do more writing sessions. No worries. Next will be Sale of Goods Act. I'll conduct 2 sessions for Sale of Goods Act. Unit 1, Unit 2, Unit 3, Unit 4. Okay? Prats, did you understand? Yeah, sure, Lavanya. I'll just update you all. Mostly tomorrow only I'll take. I'll just update you all. Yeah, the next one will be Soga only, Varsha. The next session will be Soga only. Tomorrow, mostly we'll do it. So it will be Unit 1, Unit 2, and then Unit 3, Unit 4. अरे प्राज, where are you? TXS, एक तो ऐसे ऐसे नाम लिखते हो यार, अपने नाम तो बता दो मुझे. No, 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 Harsha. I wrote as doctrine of ultrawires first. The main focus is ultrawires. Okay, okay, okay. Harsha, the main provision is ultrawires only. I've just added doctrine of constructive notice because the company cannot recover, but the main provision is ultrawires here. Did you get it? Yes, 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 absolutely. Then it would be a dormant company. Then it would be a dormant company, right?